just one authority.
Yeah, true.
I also don't want to be honest.
But the second authority largely backs up the provisions of the first authority. But basically, Your Honor, what we are asking the court is not something that is new. We are not asking the court to do something that is out of its purview. Your Honor, in miscellaneous criminal application number 162 of 2019, that is Mukhtar Ibrahim Ali versus the Republic, at page 2 of the authority that I have just submitted, I will invite the court to look at paragraph 12, line 7, which I will just, page 2 of 3, in Mukhtar Ibrahim Ali versus Republic. I invite the court to, sorry? Yes. The one that cites Republic versus Diana Suleiman Said in another. From paragraph 10 up there, and I will just quote briefly without going entirely through the entire authority. It says, with respect, I do not agree that the review of bail on the ground of changed circumstances or changes in the circumstances of the case, including circumstances of the accused, witnesses, victims, or the society affected by the alleged crime, is a strange phenomenon. I would say our courts do it every day when we seek to consider renewed applications for bail, such as when volatility on the ground is established to have ceased, or for the cancellation of bail on account of accused refusal to attend court while on bail, when surety is withdrawn, or for other reasons. What my learned senior, Mr. Krop, has submitted on, he has invited the court to look at a further affidavit that has been filed, and without going into what is contained in that affidavit, it is the state's position that since the last time we were before you in arguing the previous application, there are circumstances that have changed and that are put in this affidavit, that if the court looks through these circumstances, then it will warrant the court to grant the days that we are seeking to enable the state conclude its investigations. Paragraph 11 of that very authority says the change of circumstances test is one of common sense, that where the circumstances of the case are so altered that compelling reasons are disclosed for refusal of bail or review of terms thereof, the courts as a court of justice must reserve for itself a power to revisit the issue in the interest of justice. And this paragraph, if you read further, and I'm sure Your Honor will retreat and read this paragraph, it opens this window to both the state, the prosecution hearing, and the window is also open to the respondent or the suspect. And we are telling the court that from the last time we were before you, there has been a change of circumstance that has occurred substantially that will warrant the court to go through and give a directive or give an order for extension of this custodial order. So it is open to either side, but it so happens that in this case, it is the state that is moving the court for an extension of this period. All right. Without belaboring the point, as I finish, paragraph 12, Your Honor, on the first three lines only, The learned judge says, I find nothing in the provisions of Article 49H of the Constitution or Section 123 of the Criminal Procedure Code to suggest that once the court grants or refuses to grant bail, becomes factus officio. It is our submission, Your Honor, that based on the ruling that you delivered the last time we were before you, and in light of the provision of this authority, the court does not become factus officio by virtue of the fact that it had pronounced itself to 7 days. This very court still has the powers, in light of the change of circumstances, to extend or give additional days based on aggravated circumstances or change of circumstances. Yes.
And one under review.
Exactly. That is it. So, Your Honor, we are relying on that authority and invite the Honorable Court to grant us the prayers as sought. Basically, Your Honor, without belaboring the point, I believe the other authority also speaks to the same authority. So, without wasting the court's time, I would wish to pray that the state be allowed a further 30 days within which to obtain the respondent.
Your Honor, the application today has reminded me of some things. Your Honor, when I was growing up in primary school and learning the English language, I used to believe that prosecution and persecution meant the same thing. Your Honor, today, in fact, it is confirmed that I was not wrong. Your Honor, we have before you a person who has been in custody for over 7 days. We have before you a person who, when required, over 2 weeks before his arrest, to go to the police station and make a statement, he duly complied. We have before you a person who, after an application had been made, and you looked at all the circumstances, a decision was made that 7 days was sufficient. We were therefore coming before you today to ask that you close this file and discharge Pastor Ezekiel. Your Honor, and it is my submission that despite everything that has been said, that would be the only logical decision you should make. It is now alleged that circumstances have changed. And a struggle has been made, even by way of affidavit and submissions to demonstrate those circumstances. They are not coming out. What has changed? From the application that you dealt with, they suggested that the investigation and the matters which the respondent was suspected of included murder aiding suicide, abduction, genocide, crimes against humanity, child cruelty, fraud, money laundering. Now, when you look at the affidavit before you today, it seems that the investigations are zeroing on murder. Even by a mathematical calculation, that is a reduction. And what a state. The only thing that he points out, because you are in the application and the supporting affidavit, it was clearly alleged that there has been deaths from Pastor Ezekiel's church. It was clearly alleged that it was suspected some may have been buried at Shakahola. And the only thing that has happened now, and which was all along expected, is that the bodies that were being exhumed will be subjected to autopsy. Such that the results of that autopsy is not something new. It is not something unexpected. And it is not a change. It was clearly a procedure expected. And that those results affect Pastor Ezekiel. Ghana, the affidavit is short, and I submit that the answer is no. We are talking about the deaths which have all along been associated with another pastor called Mackenzie. From some farms which reports say belong to him, by members of a church which will say to be his flock, and Your Honor, now to drag this one here has another name. Its real name is witch hunting. Your Honor, it's my submission, therefore, that
2 more minutes, Mr. Abu.
okay.
2 more minutes.
It's my submission, therefore, Your Honor, that the result of autopsy is not a change. And it's not a change, particularly a change that they say should now amount to a compelling reason. Your Honor, the authorities that have been referred to you are anchored on Diana Salim, which, although properly well quoted and citation given, they opted not to avail. I happen to be conversant with Diana Salim. And Your Honor, the change in Diana Salim, which they are not disclosing to you here, is that Diana Salim had been charged with the offense of murder of one person. Remember the terrorist activities in Lamu. Then investigations revealed the death of other 60 people. Such that the change was from 1 count of murder to 61 counts of murder. That obviously was a change which can be described with those compelling reasons. The change here is that all other offenses have been abandoned and they are coming to murder, and they now have autopsy results. You know, I urge that you don't at all give in to that suggestion. So what Your Honor is next? Your Honor, what is expected of you now is to direct that our client be at liberty, because he has not been charged, and there seems to be, other than to persecute him, there seems to be no intention to charge him at all. Secondly, Your Honor, in the event that you feel that you want to give them some more time for whatever reason, though in my view they don't deserve at all, then Your Honor, we urge that you direct that the respondent be admitted to reasonable bail. Your Honor, it's a person you don't even need to ask to deposit cash bail or a surety. He's a non-evangelist. You can only ask him, Pastor Ezekiel, come back here on Monday, and he will come back. Just writes a note and he goes.
So you're talking about a freedom
Exactly, Your Honor.
or a personal bond.
Yeah, a personal bond, even his word without committing it on anywhere, will still count. That's all.
Your Honor, the affidavit is very, very clear. It needs days for further investigation. 3 things. Post-mortem. He will not be required to be present when post-mortem will be done, so that you retain him, because he will be required
In terms of DNA.
for DNA. His DNA sampling and analysis will be done in government premises to his exclusion. Number 2, Your Honor, they are saying he is likely to be charged for murder. When they will decide to charge him, he will be available for that charge. He does not need to be in prison or in police custody for him to be charged. You know what? They are saying that he has a lot of influence. Even those who are dead will still have influence. The influence does not wane because he's in prison. It doesn't. He still remains the most prestigious televangelist in this country. So denying him that freedom does not curtail him. You know, let me buttress, so this affidavit does not provide new compelling reasons to keep him. If this affidavit could have said, he has contacted so and so and so who are witnesses, deny him. That is not true. 2, he has been found escaping out of the country. That is not true. He has made a new passport to run out of this country. That is not true. There is no compelling reason to keep him. And Shadrach will deal with the question of the authority